Good morning, ladies and gentlemen. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to County Court at Law Number 2 because you have a case in this court. The case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. The case that you have is a misdemeanor. The difference between a felony and a misdemeanor is as follows. Your felony cases are commonly referred to as your most serious type offenses, whereas your misdemeanor cases are commonly referred to as your petty offense, means that they are not serious, but they are not as serious. They are serious, but they're not as serious. And when I talk about not being as serious, we're talking about not only the act, but the punishment that you can get for being convicted of a misdemeanor or a felony. So for example, if you are convicted of a felony, your felonies are divided into 5 categories. And we're going to start at the top and then go down to the bottom. The first the highest felony that you can get is a capital murder. Next is the first degree felony. Next, below that is a second degree felony. And below that is a third degree felony. And the lowest felony that you have is a state jail felony. If you are convicted of a state jail felony, the range of punishment, that is what you can get for that offense, is a minimum of 6 months to a maximum of 2 years in the state jail and a fine up to $10,000. For a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. For a second degree felony, the range of punishment, if convicted, is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine up to $10,000. For a first degree felony, if you're convicted, the range of punishment is minimum 5 years to a maximum of 99 years to life. That's for a first degree felony, and a range of and a fine up to $10,000. Now, the highest felony is a capital murder. And if you're convicted of a capital murder, the range of punishment is life or death. Okay, now you don't have to worry about that because we don't handle any felony cases here. And your case is not a felony case. We handle misdemeanor cases in this court. Your misdemeanors are divided into 3 categories. And we're going to start at the top and go down to the bottom. The highest misdemeanor is a Class A misdemeanor. And below that is a Class B misdemeanor. And then the lowest misdemeanor is a Class C misdemeanor. Now, the Class C misdemeanors are, for example, traffic tickets, not wearing your seatbelt, inspection sticker being out. And those cases are normally handled in our city court or handled, the city court, we call it municipal court, or it's usually handled in the JP court, which is the Justice of the Peace Court. If you are convicted of a Class C misdemeanor, and if you appeal your case, it comes up to this court. And then that's how we handle Class C misdemeanors. So if you're convicted of a Class C misdemeanor, your range of punishment is fine only. You cannot be given any jail time initially or at the beginning for a Class C misdemeanor. Now, if you don't pay your fine or if you don't do your probation, if you give them probation, then they can issue what is called a capious pro fine, and you can sit out your fine. All right. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor, if you're convicted, is 0 days to 180 days in the county jail, a fine from $0 to $2,000, or you could be given both such a fine and confinement. Now, the highest misdemeanor is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is a minimum of 0 days to a maximum of 365 days, which is a year, in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, since we're here for arraignment, the arraignment basically is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. So as a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. That paperwork that you have on the clipboard, it talks about your right to have an attorney, and we're going to go over that. Now, and the first document is titled Judge's Explanation of Rights to Defendant Without Attorney. And it states, as a defendant in a criminal case, you have three options. You have three options regarding your right to have an attorney. The first option is, number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date. It's going to be put off so that you may hire your attorney. If you want an attorney and you do not have enough money to hire an attorney, you will need to fill out a financial questionnaire. The financial questionnaire is titled Jefferson County Affidavit of Indigence, and that may be on the clipboard as well. But you would have to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to represent yourself, if you want to waive your right or give up your right to have an attorney to represent yourself, you cannot speak to the prosecutor. The prosecutor, one of the prosecutors sitting right in front of you. A prosecutor is the person that works for the assistant district attorney that works for the Jefferson County District Attorney's Office. You cannot speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. And what I mean by that is, that's the second document on there where you'll be waiving or giving up your right to have an attorney, and you'll be designed to represent yourself. So you would have to sign that first before you can talk to the prosecutor about your case. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you in your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time, and you may request counsel from the court. Now, at the bottom of that document, in bold letters, it states defendant's choice. Marking issues next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll place your initials on the first line to the left. Now, if you've already hired an attorney to represent you in your case, you will place your initials on the second line to the left at the bottom of that first document. And then to the right, you'll write the name of the attorney on the line, the blank line that's to the right on the second line. Now, if your choice is, I want to apply for court-appointed counsel, which means I want to apply for a court-appointed attorney because I do not have enough money to hire my own attorney, then you'll place your initials on the third line to the left. If you've already been appointed a court-appointed attorney in your case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you want to waive your right to an attorney, waiving your right to an attorney is giving up your right to an attorney. And if you desire to represent yourself, then you will place your initials on the fifth line to the left at the bottom. Now, once you have finished initialing one of the 5 lines, then on the line that's titled defendant, you need to write your name or sign your name, and then you will sign today's date, November 1st of 2022. Now, for those individuals who will be waiving their right to an attorney, that is giving up your right to have an attorney, and you want to represent yourself, you would have to read and sign the second document that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature of the charges against me and dangers and disadvantages of self-representation. My waiver is voluntarily, meaning that nobody's forcing me to do it. I'm doing it on my own will. And intelligently, meaning that I know what I'm doing. So my waiver is voluntarily and intelligently made. Furthermore, I have been advised this first day of November of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge, understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel. I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, you will sign your name on the line that's titled defendant, and you will place today's date, November 1st of 2022. Now, the other document, if you have a financial affidavit, we're going to give you an opportunity to fill that out later on for those of you who will be applying for a court-appointed attorney. Now, I mentioned that as a defendant in a criminal case, you have rights. And I first mentioned that your first right was your right to have an attorney. You also have a right to have a trial by jury. And what a trial by jury means is where those young people are sitting in that jury box. You have a right to have a jury listen to all of the evidence in your case. And once they finish listening to all of the evidence in your case, they will deliberate, and then they will decide whether or not you are guilty or not guilty of the charges. You also have a right to waive your right to have a jury, which means to give up your right to have a jury trial. And by doing so, your case, one, you will not have a jury trial. However, your case will come before the court, before the judge, in one of three ways. One way it will come before the judge is by way of a trial. It's a trial not with a jury, it's a trial without a jury, and we call that a bench trial. And that's a trial by judge only. The judge will listen to the evidence, and after listening to all of the evidence, the judge will decide whether or not you are guilty or not guilty. The other way that your case will come before the court is by way of a plea bargain. It's by way of an agreed plea bargain. What a plea bargain is, it's an agreement that you worked out with the district attorney, assistant district attorney of the state of Texas to settle your case. We call that a plea bargain. And your case, if you reach an agreement to settle your case with the district attorney, either you or your attorney reached an agreement on your behalf to settle your case, then your case will come before the judge, and then the judge will decide whether or not to accept or reject the plea bargain agreement. The judge will decide whether or not he or she will follow that agreement. If the judge does not follow the agreement, you can take your plea back. In essence, if you enter the plea and you and the state has worked out a plea bargain and it comes before the court and the court says, well, I'm not going to follow that plea bargain agreement, then you have a right to take it back. You don't have to go forward on it. Now, if the judge does accept the plea bargain agreement and in 30 days you decide that you would like to appeal your case, in essence, you would like to have a higher court to look at your case to see whether or not your appeal should have, well, to see whether or not you was wrongfully convicted or whether or not this court has committed an error by convicting you, then you have to get permission from the court, the judge, to appeal your case. So the judge gives you permission, then your case will go up right upstairs to the Ninth Court of Appeals, and they will review the case. They will decide to accept or reject, or meaning to grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeals. In essence, you can appeal it to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas, and it's located in Austin, Texas. And you would have to file what is called a pro se petition for discretionary review. Pro se basically means that you'll be doing it on your own. You won't have an attorney doing it for you. You'll be representing yourself, and you'll be asking them to see whether or not your appeal should have been granted, whether or not this court committed an error by convicting you, or whether or not you were wrongfully convicted. Now, if they grant your pro se petition, then they can find you simply not guilty, or they can send the case back down to this court, or to this court to give you a whole new trial. Or if they deny your appeal, your pro se petition, your conviction will stand at that point. So just to recap, you have a right to have an attorney. You could either hire one, you can see if you qualify for a court-appointed attorney, or you can waive your right for an attorney and represent yourself. Your case can come before the judge by way of a bench trial. If you waive your right to have a trial by jury, then it will come before the court. And that we call that a bench trial. Now, if you and the state have reached a plea bargain agreement, we call that an agreed plea bargain. The court does not have to follow it, but if the court does follow it, you have to get permission from the court if you desire to appeal your case within 30 days. Now, the next way your case will come before the court is by way of an unagreed plea bargain. Unagreed means you and the state have not been able to reach an agreement, so you want the court to assess your punishment. You want the judge to say what your punishment will be in your case. We call that an unagreed plea bargain agreement. Now, the other right that you have, besides your right to have an attorney and besides your right to have a trial by jury, as well as your right to enter a plea bargain or unagreed plea bargain or have a bench trial, the other right that you have is a right to have witnesses to come to court to testify. Now, witnesses, they sit in that chair right there. We call it the witness stand. They can either testify for you or against you. And you'll have a right, if you're representing yourself, to ask some questions. If you have an attorney, your attorney have a right to ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses to come to court, which means you have a right to give up your right to have witnesses to come to court. That simply means that you won't be calling witnesses. Now, just because you won't be calling witnesses in your case does not mean that the state will not be calling witnesses in your case. It doesn't mean that. And they will be calling witnesses in your case. And you'll have a right to ask them questions, either direct examination or cross-examination. You also have a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your own case. The state of Texas, no one can force you to testify against yourself in your own case. We call that taking the fifth. Some people say, well, you might have seen on television, people say, well, I take the fifth. That means that I'm not saying anything. I'm not going to say anything in my case. And you can't make me say anything against myself. So, however, you can waive or give up your right to take the fifth. And if you waive or give it up, then you will be taking the witness stand to testify in your case. You also have a right to have discovery. Discovery means you have a right to see the evidence that the state has against you. If you want to see the evidence, you have a right to have access to the evidence. And what I mean by evidence, I'm talking about documents. It could be documents, it could be witness statements, it could be videos, it could be tape recordings, it could be objects. Any evidence that the state has against you, you have a right to have access to that evidence. Now, you don't have a right to get it, but you have a right to have access to it, to look at it, view it, and do whatever, so you can prepare for your trial. Now, you can waive or give up your right to have discovery as well. That simply means that you do not want to have access to the evidence that the state has against you. Now, As a defendant in a criminal case, first of all, everyone in here who's here for their case, you have been arrested and you're out on bond. You're out of jail either you paid a cash bond to get out of jail, meaning that you paid the full amount, or you paid a surety bond, which means you had a bondsman, you paid them a percentage of what the bond was, and so that's a surety bond. Or you was let out of jail on what is called a PRA bond. PRA means personal recognizance, meaning that you did not have to place any money to get out of jail. However, you was released on your own recognizance and your promise to be here in court. All right. Now, every day that you spent in jail can be used as credit toward your punishment. So, for example, let's say you spent 5 days in jail, and let's say you and the state or union have reached a plea bargain agreement. They're offering 5 days in jail. You've already spent 5 days in jail. Guess what? That simply means you won't have to spend any more time in jail because you've already spent 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, every day that you spent in jail also can be used toward your fine and court costs. So every day that you spent in jail, you will get $100 that will go toward your fine and court costs. So if you spent, using the same example, spent 5 days in jail, that's $500 that will go toward your fine and court costs. So for example, if the state is offering you fine and court costs to settle your case of $500, you already spent 5 days in jail, you won't have to pay anything. Why? Because the time that you spent in jail has already paid it off. Therefore, your fine and court costs will be taxed and retired, which means you won't have to pay it. All right. Now, for people who have been here, if you're here for the first time, you haven't been in trouble before, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program where the state of Texas, the district attorney's office that is, will dismiss your case. You complete the program, you can get that case expunged, wiped off, or deleted from your record. And in order to qualify for the program, one, you have to get an attorney to assist you at making the application. Two, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And three, it has to be your first time getting in trouble with the law. If you are a veteran of any one of the branches of the United States military, Jefferson County has a pretrial program that's called Veterans Court. And with the Veterans Court, the only criteria is you have to be a veteran of any one of the branches of the United States military. You get into the program, they dismiss the case, you can get it expunged from your record when you complete the program, just like pretrial diversion. So in order to get in that program, you just basically have to be a veteran of any one of the branches of the United States military. Now, Jefferson County, well, this court, County Court at Law number 2, we have a program that is called the CSI program. CSI stands for Community Safety Initiative. That's a program that I started within the first 100 days of taking office. So the program was started on March of 2017. That program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. And the way the program works is like this. We have partnerships with agencies in the community. One of the partnerships that we have is with Spindletop. Spindletop is our local mental health agency, our mental health center, Spindletop Center. The young people in the jury box are from Spindletop. They will come and speak to you a little later and tell you about the program. But basically, the program that we have with Spindletop, the program is for individuals who have some mental issues that may need to be addressed. Now, you don't have to be insane or incompetent. You could suffer from anxiety, depression, bipolar, schizophrenia, ADHD, or any host of mental issues. They can do a private interview, develop an assessment plan, and develop a treatment plan. They can do an assessment and develop a treatment plan for either outpatient or inpatient treatment. Other program that we have with Spindletop, and also we have the program with our local Drug and Alcohol Council. Spindletop has ATAR, and the local Drug and Alcohol Council has OZAR. Those programs are programs designed to address individuals who have problems with drugs or alcohol. And the way the program works is they will do screenings, assessments, and they will develop treatment plans, either outpatient or inpatient treatment as well, to address any alcohol or drug-related issues. If you are unemployed or you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center. We have a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in one of the areas that you select, they will assist you at getting a job in those areas. Now, if you have not graduated from high school, well, they have a program, it's a GED program where they can assist you at getting your graduate equivalency diploma. Now, all of these programs that I just mentioned are free. It does not cost you anything. Only thing you have to do is have a desire to be in the program. And that program, as I stated earlier, addresses the issue of recidivism when people commit crimes over and over. And so the way we address the issue of recidivism, we need to break the cycle. The cycle usually starts when a person don't have an education, they can't get a job, They usually turn to drugs and alcohol. Once they turn to drugs and alcohol, they usually commit a crime. And once they commit a crime, they eventually get caught. Once they get caught, they do time. And once they do time, they get out. And when they get out, they're back in that same cycle. So to address that cycle, we have our community safety initiative. Now, all of these programs are free. It does not cost you anything. Only thing you have to do is have a desire to be in one of the programs, and we can give you information on that. I tell people this all the time. When you come to County Court at Law number 2 in Jefferson County, we do not have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court, and we're trying to make a difference in Jefferson County, the county in which we live. And so in this court, we do not just give time, we take our time. And we are not just arresting the problem, we are addressing the problem. And we believe that by addressing the problem, we can produce productive people. And by producing productive people would not commit crimes because they have too much to lose. And so therefore, we make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and raise our families. And if you're interested in any one of these programs, when you come up, just let us know. And we have someone here who can assist you at getting you into the program of your choosing. Now, at this time, we would have Deputy Hinton and Sarah to come forward. They're from Spindletop, and they can tell you something about the program that Spindletop has to offer. Deputy Hinton and Sarah. You're welcome. You're welcome.
My co-worker, she is qualified in her profession. The reason we are here this morning in this courtroom is because the judge here is not a person. What the judge has found, and this statistics actually proves those who appear in courtroom issues have mental health, substance use disorder, or sometimes just a lack of community resources to help you. Goal and objective today is to get you out of the rest. I know this is the first time to be here, even if you're the 10th time to be here, there's still hope. Sarah actually has a program in place that will plug you into community resources that will help you with this. We don't know what that is, so we're going to ask you to share that need with us this morning. In fact, Sarah has presented y'all with a demographic sheet. She's going to explain to you what we're going to do with that sheet and how we're going to use that to benefit you and your particular situation.
Good morning. So like Steve said, this document is to help us get more information from you so we know how to help you. The information at the top, it asks what type of resources you need in the system, because the judge went over how many resources that are available to you that are absolutely free. You can write that in that link. Above that, it asks how we can contact you, whether it's a call or a text. Sometimes the text is easier when you are busy, jobs and such. And if that's easier for you, for us to contact you through text, then that's how we will contact you. All of this information is super regulated, meaning that we cannot share this information. So, know that your information is safe within.
Also, I want to give you this handout before you leave here today. On the back, it tells you a little bit about our program and some of the advantages of taking opportunities here. Also, on the front is a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help you need. If you don't remember anything we said this morning, I want you to remember this. We are here to help you. We want to help you, but you're just going to have to share that need with us so we can help you directly. That need will be private. We will not be outside of your presence. It's there to help you should you want to take advantage of it. And maybe this doesn't apply to you. Maybe it applies to a family member. We'd be glad to work through you to help that family member as well get the help that they may need. Thank you. Thank you, Your Honor.
Thank you, Deputy Henry Sheriff. Now, ladies and gentlemen, the information that you have on the clipboard, the one that talks about Jefferson County Affidavit of Indigence, that information, that first page, if you are requesting an attorney be appointed to represent you, you need to fill out information out. Now, basically, it has your information as to your name, your address, telephone number. It also asks whether or not you're married, single, divorced, separated. Also, there's information on there to see whether or not you received any type of governmental benefits. If you do, you need to check one of those boxes. It also, if you have any children that you're under the age of 18 years old or younger, you need to list your names of your children and their ages. And it also asks about your living situation, whether or not you own a home, you're renting, you live with a family member or relative, or whether or not you're homeless. And then at the bottom of that document, on the left side, it asks you for your monthly income. Now, if you are employed, they just need to know what your take home is a month. And if you have a spouse, what your spouse's take home is per month. And if you're receiving any type of child support, what that amount is. Now, if you're receiving any type of governmental benefits, you need to put that amount, also the amount that you're receiving per month. And if you have any assets such as a home or car, you just kind of estimate what the value of that is. And then at the bottom where it says total on the left-hand side, you just have to total what's in that column. Now, on the right-hand side of that document at the bottom, it asks you for your monthly expenses. It asks you whether or not you're paying a rent or mortgage, or then it goes down and asks whether or not you have any utility expenses, like gas, water. And if you're receiving any child support, it also asks what your food expenses are per month. And then when they ask for transportation, it's not only what you're paying in gas per month on your travel, but if you are paying car insurance, if you're paying a car note, that should be totaled up as well. Now, if you do not own a car, if you're paying somebody to transport you, Uber or cab or whatever per month, you need to put that information on transportation. Now, if you are on probation, you have probation fees, you're going to put that down per month. And if you have any medical expenses, you put that in. So when you get to total, you're going to put the total amount. On the next page, it talks about it's an oath. You read that oath swearing that everything is true, and then you'll sign it. And then at the bottom, it's an unsworn portion. It says unsworn declaration. You're going to fill that information out as well. Then you'll be complete. You'll be finished with that form. Okay, so at this time, if you need any help or assistance with filling out the forms, we have our court personnel here who is able to help you. And at this time, the court is going to take a break to give you time to fill out that information. Now, for those of you who need to use the restroom, right outside the court there are some restrooms to your right. The men is on the right-hand side, and then across the hall is the women's restroom. Okay, so if you need to use the restrooms, you can go out into the hallways and then make sure that you come back into the courtroom, because if you do not come back in the courtroom and your bond may be forfeited, if your bond is forfeited, you're gonna have a warrant issued for your arrest. So at this time, this court will be in recess.